26 to 25 has not been filed. But necessary orders in terms of this, or in terms of the order of this court has been passed, which is dated 11 to 2025. Submits that if some time is granted, then the amount payable to the petitioner will also be debited to his bank account, and supplementary show cause will be filed along with details of payment. A copy of the order dated 11 to 25 has been reviewed before this court, which is kept on record. A copy of which has also been provided to the counsel for the petitioner. Post this case on 18th of March in the supplementary cause list. The compliance report after remitting the addressable amount to the petitioner be filed latest by 10th of March.
Item 4, contents in the 68 of 2025.
They filed the second show cause. Their intention is to frustrate the order of this honorable court. How if I am permitted, I can argue minutes. The Lordship has directed me to file a representation. Pursuant to that order, I have filed a representation. The first representation was in English. We have drafted that representation and have given to the office of concerned opposite party. Subsequent thereto, after some time, court was not sitting. My client was going, they were filing the attendance, court was not sitting. Subsequent thereto, when the presiding officer was not holding the court, when he started holding the court,
representation was to be filed in the
before the deputy commissioner.
He was holding court from time to time. He holds court.
No, because of elections, ensuing elections, he was not sitting.
Okay.
And after that, when he started sitting, office of the deputy commissioner has conveyed to my client that you file representation in Hindi. Subsequent thereto, he has filed a second representation in. I have received instruction. I'll file that.
Instructions.
I'll file that. I'll file that because he is coming with that representation which is filed in Hindi. So in that representation, the party's name are not there. So my contention to that effect is that the second representation which was given in Hindi is continuation of the first representation. How they can say that the details of parties were not given? Because they have stated in their show cause that the details of parties, the first representation which is there on record.
First representation has been filed, it was never filed.
Well, the first representation was there, it is there.
It is
the
there.
The details of the parties are there, so
yes.
We have stated.
Yes,
in our earlier order also,
it is there.
at page number 33.
Paragraph that representation is Annexure A. Subsequently, they have filed a second representation. That is not on record here, but
it is very much on record.
No, the second representation.
Second representation is not there on record.
So how are you concerned with the second
I'll explain. The second representation, I've seen that. There is.
Why have you not annexed?
My lord, we are bound by this statement of facts, etc., which come. But I've seen that it was not signed by any of the parties.
Forget about second. One is
that
enough.
That is the only reason.
One is enough.
It was signed by the advocate, that's all.
Forget about the second.
But up to that reason given, my lord, is that there are twofold reasons. That all the did not file a joint representation, all the legal layers of Deepak Kumar Thakur. That is the reason given.
All means?
How can they file melons?
What was the order?
Well, see the order. The operative part.
Para 18 melons. Sorry, page 18. It starts. It appears from paragraph 11 of the counter affidavit.
Accordingly, these three petitions.
No, before that,
melons. Page 18, if your lordship comes.
Yes.
It appears. Second line.
It appears.
It appears that paragraph 11 of the counter affidavit, the consent is required from all legal heirs of late Rohan Thakur, son of late Surjan Thakur, in favor of the petitioner, or his mother Dubeshwari Devi, wife of such and such, or his brothers, that is Dilip Thakur, Paleshwar Thakur, both sons of late Kripal Thakur, for releasing the amount mentioned in the paragraph of the counter affidavit. Although it has been stated by the writ petitioner that such consent is not required in view of the certain title deeds which has been filed by them in the writ petition, but this aspect of the matter is also required to be considered a responsible to in the light of other available records. Accordingly, these writ petitions are disposed of, enabling the petitioners of these cases belong to the same family to jointly approach the respondent. So jointly was to be approached. There was a direction for all these petitioners.
That's
By
right.
filing a detailed representation with supporting documents and a copy of writ records and a copy of this order dated 3rd of July 2023, in the representation they may also disclose the persons whose rights may be affected. We have disclosed that. All the legal heirs of the Red Lohan Thakur, we have disclosed that. Upon filing of the representation, so how, they are trying to frustrate. Now
After
subsequently,
giving an opportunity
Yes,
of
my lord.
hearing to all the concerned persons.
yes, my lord. So they are trying to frustrate
You
it.
see,
Now
if you
subsequently,
have, if somebody does not come and he is a legal here, we'll have to issue notice. Pro forma party बनते हैं ना.
Here they won't be pro forma because they are all interested parties. They are all entitled to a share.
You
Your
see,
Lordship.
if they are not approaching, you see, your entire case in the writ petition was that they have not, all of them have not joined. Correct?
My lord.
We disposed of we asked you to consider their representation. We asked them to disclose all the legal heirs. They can't, you see, if the legal heirs are not joining with them, their right is not frustrated. The only thing you can do is you can call upon the legal heirs and ask them, what do you have to say? Simple. कौन है डेप्यूटी कमिश्नर जो ये बात समझ में नहीं आता? कहाँ का डेप्यूटी कमिश्नर?
Chadra, Your
Chitra,
Lordship.
my lord.
चतरा को नहीं समझ या आपको भी समझ में नहीं आता?
Yeah, I have understood what Your Lordship is saying,
It's
but
very simple.
Order is very clear, my lords. Now they are trying to frustrate it by saying subsequently they are asking that you have
आप उनको
filed
बुला
representation in
लीजिए।
English.
उनको नहीं समझ आ रहा।
नहीं, नहीं, ठीक
ठीक है, हमको बुला लेते हैं। बताइए कब बुलाएं?
after any time Your Lordship, like speak anytime.
Content Civil 68 of 2025. क्या लिखे हैं इनको सेकंड प्रोपोजल में कुछ
Well, second show cause they have stated that we have not disclosed the name and
Paragraph 13 and 14, Your Lordship, of the supplementary show cause notice.
Content Civil 68 of 2025, the responsible for the parties are present. A supplementary show cause has been filed in this case.
Page 20.
Pursuant to order
6/2/25.
dated 6/2/2025, and it has been stated in paragraph 13 that all legal heirs of Rohan Thakur did not find a joint representation before the respondent, and have also and in paragraph 14 it has been mentioned that the petitioners have also not disclosed in the same representation as to whose right will be affected. The learned counsel for the petitioner has again referred to the representation filed by the petitioner
page 23, paragraph 8.
and has submitted that in page 23, paragraph 8,
8 to 13, my lords.
8 to 13, the name of all legal heirs have been mentioned. The whole purpose of mentioning the name of the legal heirs was that they are the persons whose right are bound to be affected. He has submitted that the learned counsel has also referred to the order passed by this court and has order dated
My lords, order dated 3rd of
12/6/2023 passed in WPC number
3rd of July 2023. Passing batch writ petitions.
in batch of writ petition being WPC number 2385 of 2022 and other analogous cases, and has submitted that the deputy commissioner ought to have issued notice to the aforesaid persons so that the matter could be the order of this court could have been complied. But having not done so, the show cause revealed, the supplementary show cause revealed that the Deputy Commissioner is of the view that the petitioner has not disclosed the name of the persons who will be affected. The learned counsel submits that once the legal heirs and successors, list of legal heirs and successors have been mentioned in the appropriate paragraph, there was no need to give a separate statement that their rights was to be affected. It seems that the Deputy Commissioner has either not understood the import of the order passed by this court or is not willing to comply the order in letter and spirit. In such circumstances, this court directs the opposite party number 2 यही है कोई और नहीं? To appear in person before this court on (25th of February)
Yes.
at 10:30.
I may request you, can it be on 27th March? Because 25th my son's birthday is there, so I will not be available.
On 28th of February, on Friday.
That's okay.
In the supplementary for this to be taken up at 10:30 and in the as the first case.
Okay.
For hearing under order 41/11, item number 5, second April 56 of 2022.
Yes.
Yes. Well, this is plaintiff's second appeal against the judgment of reversal in relation to counterclaim filed by the defendant. Plaintiff
Just a moment. Counterclaim was rejected initially.
Yes, counterclaim was rejected, my lord, and that counterclaim has been allowed by the appellate court. Relief, there were some reliefs, my lord, two reliefs before starting, my lord, the file. Two reliefs was claimed by the plaintiff. The sued property is one of the quarter of housing board. It is of housing board Hazaribagh. Now, plaintiff himself admitted that in an abundant suit, he entered into possession and subsequently it was allotted to him. Now, defendant number 1, 2, 3 were the original allottee who did not pay the rent and subsequently his allotment was cancelled by housing. So, the plaintiff's reliefs was not against housing board, rather it was only against defendant number 1, 2, 3, first allottee, that they cannot evict me forcefully without taking the course under defendant number 4. Defendant number 4 was the housing board. So this was the reliefs claimed by the plaintiff. Now suit was decreed in so far as first relief is concerned, that defendant number 1, 2, 3 cannot evict the plaintiffs forcefully, but other relief was not granted. Plaintiff has not challenged that. because my lord will find subsequently that the same was allotted by housing board. Now that's why the plaintiff did not challenge that judgment. One issue was related, relief was granted. In the trial court, along with written statement, counter claim was also filed by the defendant number 123. Now his counter claim was not registered. Counter claim was filed along with written statement.
Court fees paid?
Court fees paid, my lord, because honorarium court fee is written there, but now
Did you respond to this counter claim?
no, because no issue was there, it was not registered. And my lord is well aware that in terms of order 8 rule 6a, if counter claim is filed, it is to be treated as plain, and thereafter written statement not filed, then evidence is to be taken in respect of the counter claim.
Certainly,
Sir,
it's as per the
yes, obliged. So now the defendants, in respect of counter claim, has not laid any evidence. They laid evidence in the original suit only.
What was their counter claim?
Counter claim was in relation to the same quarter, that they should be given to his right should be declared and possession should be given to them.
They were seeking declaration of their
Yes,
rights.
yes.
Title.
Title right under housing board. Under housing board. Now, what my lord will find only certain paragraphs.
Let us see how the appellate court has allowed.
Yes. I was just showing my lord appellate court's judgment only. My lord, appellate court's judgment, my lord. My lord, paragraph 20.1. Just a minute. My lord, internal page 13, my lord can find the reliefs claimed by the defendant number 2, paragraph 4.13. So now thereafter just only cut short the matter. Page 16, paragraph 5.8. This is their pleading in the defendant's pleading, which has been taken down. Page 16 of the learned appellate, first appellate court's manner, 5.8. The quarter in question has already been allotted in favor of the plaintiff. So now the suit of the plaintiff is futile as the relief sought by the plaintiff has been decided in his favor. Now, my lord, kindly see paragraph 6. The issues were framed from 1 to 10. No relief in relation to counterclaim. Now, my lord, kindly comes to this one. Paragraph 47, my lord, page number 40. defendant number 2 has a right claim over the suit premises quarter number so and so on the basis of his allotment by the defendant number 4. The trial court has wrongly dismissed the counterclaim. So the appeal is allowed. Now this is second point. Now second paragraph, the appeal is allowed and judgment of dismissal of counterclaim passed by the London trial court is set aside. Now appeal is allowed means entire judgment was set aside. So far as the relief with respect to the defendant number 1, 2, 3 cannot forcefully evict me, that relief has also been reversed. And my lord has seen that is the case of the defendant themselves. They have admitted that the suit property has already been allotted, they are in possession.
कहाँ है तो substantial question?
My lord, point number 6. Receive.
What did the trial court do so far as the counterclaim is concerned?
My lord, just showing it.
Did they pronounce anything on
No,
counterclaim?
nothing. They have taken out, they have only filed, since no evidence was laid, my lord, so they,
It was recorded.
just, my lord. My lord, internal page 5 of the trial court says, my lord. My lord, first paragraph, second line, defendant also claimed relief through counterclaim. Internal page 5 of trial court judgment.
Yes.
Now, my lord will find in the first paragraph, defendant also claimed relief through counterclaim that the said quarter must be handed over. So his counterclaim, as a matter of fact, not registered. Had it been registered, original suit number was to be given, then issues was to be separately framed. My
वो
lord,
सब तो आप substantial question of law में कुछ बनाए नहीं।
नहीं, what point number C बना है, उसको reframe कर देते हैं. Whether the findings of the London Court of Appeal are vitiated due to misconstruing the provision contained in order 8.
बहुत अजीब है।
हाँ, थोड़ा सा इसमें और ये
क्या ये substantial question of law?
my lord may frame.
There is no evidence that the allotment made in favor of the defendant has been cancelled prior to your allotment.
हाँ, but it was subsequently allotted.
Subsequently allotted, but there is no cancellation.
हाँ, there was no cancellation.
There was no cancellation. And under such circumstances,
But at least since allotment was made, I was in possession.
it is an admitted fact that allotment was made.
Yes. Defendant number 4, Housing Board has filed a written statement. I can show from there.
And there is no evidence on record that the allotment in favor of the defendant has been cancelled prior to the allotment.
Yes. Prior.
Which is also an admitted fact.
Yes, this is also an admitted. There is no record. I cannot argue beyond record.
So फिर counterclaim में क्या ही किए हैं?
That's why, my lord, I was telling this one. ये अगर if it would have been registered and suit number was to be given, then both parties were required to give evidence, issues were to be framed. Because my relief was already granted by the learned trial court. Appellate court has presumed that since I have not challenged that uh, entire judgment, so everything has to be presumed, and then all issues has to be decided against the plaintiff, and that's why counterclaims should be allowed.
आपका क्या डिग्री किया है? What degree? Now in view of the
नहीं, अपीलेट कोर्ट तो मेरा डिग्री खत्म कर दिए ना।
नहीं
ये
आपका
trial
ट्रायल कोर्ट क्या डिग्री?
वो ये कि हमको एक फोर्सफुली ये एविक्ट नहीं कर सकते हैं इसका, ये निकाला।
हाँ।
मतलब पैराग्राफ 16 इंटरनल पेज 12। Defendant number 1, 2, 3 have no legal right to evict the plaintiff from the suit premises since there is an allotment in favor of the plaintiff by the defendant number 2. The legality of the defendant allotment have not been questioned by the. I have shown the admission also in counterclaim. Neither there is evidence for such legality of allotment. Hence, in present scenario, defendant number 1, 2, 3 have no right to evict the plaintiff from the suit premises.
heard the learned counsel appearing on behalf of the applicant. The learned counsel for the applicant has submitted that appellants, more than one, no? How many persons are there? The learned counsel for the appellants has submitted that the appellants were plaintiffs before the learned trial court, and the suit property was a flat of housing loan. The claim in the suit was that the defendant number 1 to 3 were not entitled to evict the plaintiff forcibly till the pendency of prayer before the defendant number 4 within that date the housing loan. The learned counsel has submitted that the defendants were the original allotee.
Unit number 1 to 3.
Defendant number 1 to 3 were the
Original allotment was made in favor of defendant number 2. Appealants.
defendant number 2.
Yes.
The original allotment was made in favor of defendant number 2, which was prior in point of time, and the plaintiffs were in occupation of the suit premises, and their prayer for allotment was pending before defendant number 4. Correct?
Well,
He submits that in the suit, a counterclaim was also filed, but the counterclaim was also filed by the defendant number 2, asserting that defendant number 2 was legally allotted the quarter and was ready to deposit the arrears of rent to the housing bill. And had valid right to get the quarter in vacant possession from the plaintiff. It was asserted by defendant number 2 that the plaintiff was only having permissive possession and there was no allotment in favor of the plaintiff. The defendant claimed relief to counter to him without any objection, and defendant number 2 claimed the declaration of right over the said quarter allotted to him by defendant number 4 on 18/3/1994 and claimed that the plaintiff was liable to be evicted. The learned counsel submits that although the counterclaim was filed, but the same was never registered as such, and therefore there was no occasion for the plaintiff to file a written statement to the counterclaim. He has also submitted that neither any issue was framed in connection with the counterclaim, nor parties led any evidence in connection with the counterclaim. The learned counsel has submitted that as per the and in the said scenario, it was held that defendant number 1 to 3 have no right to evict the plaintiff from the suit premises. The trial court also recorded that there was no evidence on record The learned trial court also recorded that the relief prayed for by the plaintiff was infructuous, and the relief prayed for by the defendant number 1 to 3 cannot be decided in favor of allotment in view of the allotment having been made in favor of the plaintiff. It also recorded that there was no evidence on record that allotment in favor of the defendants had been cancelled prior to allotment in favor of the plaintiff. Hence, the suit was dismissed along with the counterclaim. The learned counsel submits that since the suit was dismissed, the learned counsel submits that since there was a clear observation that the defendant number 1 to 3 had no right to evict the plaintiff from the suit premises, the defendant filed their appeal and defendant filed their appeal to the extent the counterclaim was dismissed. The learned counsel has submitted that the counterclaim has been allowed by the appellate court. After observing that the plaintiff slash the defendant number 4 did not file any reply or written statement to the counterclaim. Para 22 में है ना?
Well,
Paragraph 26 of the appellate court judgment revealed that claim was filed on 17/5/2012. Counterclaim was filed by defendant number 2 on 13/5/2013, and the repetition and the written statement was filed by defendant number 4 on 9/7/2013. But the defendant number 4 in his written statement had not contended any part of the counterclaim. The sole point for consideration by the appellate court was कहाँ क्या पैरा में in para 13, the sole point for determination whether the learned trial court has rightly dismissed the counterclaim of the appellant. The learned trial court held that the learned appellate court held that the trial court wrongly dismissed the counterclaim and allowed the appeal, and the judgment of dismissal of counterclaim passed by the trial court was satisfied. And there was a direction that the defendant number 2 was entitled to be put in khas possession of the two premises after evicting the plaintiff by due process. The learned counsel has submitted that since the counterclaim was not separately registered, no relief could have been granted with respect to the counterclaim. Then under such circumstances, it ought to have been remanded.
हाँ इसीलिए उनको रिमांड कर
The
देना चाहिए
learned counsel submits that on such premise, the matter ought to have been remanded to the trial court. He has also submitted that in absence of any evidence in connection with the counterclaim, the evidence in the suit could not have been taken into consideration to allow the counterclaim, particularly when the plaintiff did not file any written statement to the counterclaim, having not been formally registered. Yeah.
Yes madam and defendant had not challenged the allotment उन्हें दी रिजल्ट
वो तो बात का subsequent development
जी.
है. Considering the aforesaid submissions, this appeal is admitted for hearing on the following substantial question of law. Like CPC. Whether the learned appellate court failed to consider that the provision of Order 8 Rule 6A of Code of Civil Procedure was not duly followed by the learned trial court, which has led to not duly followed by the learned trial court, which has, as the same itself was not registered separately, and consequently no written statement was filed by the plaintiff to the counterclaim, and no evidence was led by the parties in connection with the counterclaim. Wait, Ajaya, issue notice to the respondent number,
All the respondents, both of them.
to the respondents, इनको भी जाएगा, executive info, to all the respondents under ordinary process for which requisite be filed by the applicant within a period of 1 week. Let records be called for from the concerned court. Let this order be communicated. Post this case on 6th of March.
Duplicate.
Item 6, second appeal 161 of 2022.
Appellant,
May I please? This is plaintiff's second appeal against the judgment of affirmance. In this case, my lord will find, my lord, only just I will show, my lord, the district London First Appellate Court's internal page number 7. My lord, plaintiff files suit for declaration of his title over a purchased lands. Purchased land by virtue of registered deed. My lord, internal page 7 of civil appeal, First Appellate Court. Now, a very nice pictography has been framed by the learned First Appellate Court, which itself proves the case of the plaintiff. If my lord will find that name of plaintiff is this ballot Venn diagram, plaintiff Panchanan Pandit in the lowest right side, and even it has been given that how much land has been purchased, and I am claiming my right over only in respect to this land, and I have produced my registered deed option. But my lord, my humble submission is that both the trial courts as well as the First Appellate Court has gone beyond my sale deed and has held that plaintiff has no right title over their purchase. Only on the basis of the recital, this page is enough, my lord. On page number 7, my lord will find that it is written in the sale deed of, my lord, I purchased this, Panchanan Pandit purchased this land from Krishnakant Pandit. Now Krishnakant Pandit purchased the land from the original owner Badri Narayan Parichit. Now in the sale deed of Krishnakant Pandit, it is written 200 square feet of the land, 2000 square feet of the land has already been sold to Sudha Rani. ये लेफ्ट साइड में जो सुधा रानी को जो सेल डीड से किया, तो इसके बाद भी जो सेल डीड सुधा रानी को हो गया, इवन देयर आफ्टर the lands remaining land was sold to the Krishnakant Pandit, and that Krishnakant Pandit has sold the lands to two persons, Venu Chaudhary and plaintiff Panchanan Pandit. So my lord, my claim is only with respect to the my lands purchased by virtue of registered deed of sale. Right of vendor is admitted. Original owner the right is not in dispute, and it has been very nicely quoted. But this has been my lord, discarded, that the plaintiffs is claiming their lands, his lands only over his purchased lands.
Where is the finding?
My lord, just below my lord, 8.2. From the sale deed of Sudharani, it is explicit that on the north side there is land of Badri Narayan Parikshit, on the south side there is land of Badri Narayan Parikshit, on the east there is mother so and so, so and so.
ऐसा so and so मत
My lord, मेरे relevant पढ़ते हैं.
नहीं आप
My lord, please. From the sale deed of Sudharani, it is explicit on that on the north there is land of Badri Narayan Parihas, and on the south side there is also land of Badri Narayan Parihas, and on the east there is Maja Gurgura, and on the west there is 15 feet proposed road. That on both the direction, north and south, there is land of Badri Narayan Parihas, original owner. Further, if we will see the boundaries of the sale deed of Krishnakant Chaudhary, it shows that on the north there is land of Badri Narayan, and on the south there is circular road. The rest of directions are not disputed. The Krishnakant Pandit is vendor of Benu Chaudhary and Kanchanand Singh. If we see the boundaries of sale deed of Benu Chaudhary, it shows that on the north side there is land of Krishnakant Pandit, and on the south the land of Krishnakant Pandit, which is to be sold to the Kanchanand Singh. The rest of the directions are not disputed. Further, if you see the boundary of the sale deed of Kanchanand Singh, plaintiff, on north there is a land of Krishnakant Pandit, and on the south circular road, and rest of the boundary are not disputed. In the sale deed of Kanchanand Singh, nothing is mentioned on which side land is being sold to Benu Chaudhary. This is very important. This is my sale deed. Well, just for a moment explaining manner. This is my sale deed, where the remarks of the learned first appellate court that in the sale deed of Kanchanand Singh, nothing is mentioned on which side the land is being sold to Benu Chaudhary. बीनू चौधरी को सेल हुआ सब्सिक्वेंटली उसी दिन बाद में. तो बीनू चौधरी का जो लैंड है, दिस कैन नॉट बी सोल्ड. नेदर बीनू चौधरी के जगह पे जो वेंडर है उनका नाम सो. एंड वेयर एज ऑन द लैंड ऑफ बीनू चौधरी इट इज रिटेन that on the south of her land, the land is proposed to be sold to Kanchanand Singh. My name is there. That means that Kanchanand Singh was on the south side of Binu Chaudhary. When Kanchanand Singh is on the south side of the Binu Chaudhary, then automatically Binu
आपका
Chaudhary.
वेग प्रॉपर्टी डिस्क्रिप्शन के कारण आपका केस
हाँ दिखा रहा, but sale deed is on there.
तो सेल डीड होने से क्या होगा?
तो sale deed
सेल डीड होगा, मान लीजिए प्लॉट नंबर
I got my lord. Yes, I got.
बाउंड्री नहीं है, कुछ नहीं है, तो किसका क्या चीज?
इसलिए that's why my lord I was saying. That's why kindly see my lord, ये boundary का
सेकंड
detail.
अपील में ये क्या ही हम लोग डिसाइड करेंगे?
Yes, my lord can decide. I am not saying that my only submission that my sale deed has not been disputed.
There is no question of any dispute, but your sale deed is vague because there is no proper boundary.
What boundary is given? Kindly see. वो जो अंडरलाइन जो दिखा है my lord को, in the sale deed of पंचानन चौधरी, कोर्ट क्या ऑब्जर्व कर रहे हैं? In the sale deed of पंचानन चौधरी, nothing is mentioned on which side the land is being sold to बीनू चौधरी. बस यही रुझान. कोर्ट मेरे एडवर्स में क्या बोल रहे हैं कि आपके सेल डीड में बीनू चौधरी का नाम नहीं लिखा हुआ है कि बीनू चौधरी को कौन जमीन बिक रहा है. तो क्यों लिखा रहे?
किस तरह?
किसी भी तरफ एडमिटेड है कि जो वेंडर है उसको राइट था. अब सेल डीड अगर पहला मेरा हुआ, मेरे बाद बी को,
कैसे पता बिल्कुल बात नहीं? ऐसा कोई
हाँ,
फाइंडिंग
नहीं यही है.
यही है मतलब?
बिकॉज आई कैन
उनका सेल डीड कौन सा है?
सेल डीड ऑन द सेम डे. नंबर इज डिफरेंट.
नंबर किसका पहले?
Now that's why my lord I am saying that if on my cell deed, name of any other person is not written. It means my cell deed is vague. Ballot it cannot.
बाउंड्री तो कैसे
बाउंड्री नहीं दिया हुआ है ना. बाउंड्री में क्या कर रहे हैं कि नेम ऑफ बीनू चौधरी की जगह पे उनका अपना नाम लिखा हुआ है. आगे पढ़ते हैं मैंने. I may be थोड़ा little bit हम समझा नहीं पा रहे. It is written that on the south of her land, the land is proposed to be sold to Panchanan Sati. That means that Panchanan Chaudhary was on the south side of Binu Chaudhary. When Panchanan Singh is on the south side of Binu Chaudhary, then automatically Binu Chaudhary is on the north side of the Panchanan Chaudhary. The court is assuming कि उनका
in
नाम
the sale deed of Panchanan Singh.
Yes,
This is
Meera.
the sale deed concerned plaintiff.
yes plenty.
Nothing is mentioned on which side land is being sold to Binu Chaudhary.
Yes इसी को पहले take note of it.
And whereas on the land of Binu Chaudhary it
Yes.
is written that on the south of her land the land is proposed to be sold to Panchanan Singh.
बस यहीं पे बैलेट kindly take a pause. Meaning thereby in
Not
the
a Binu.
नहीं एक मिनट. In the sale deed of Binu Chaudhary दूसरे के सेल डीड में ये लिखा हुआ है कि जो वो प्रॉपर्टी है पंचानन सिंह प्लेंटिफ वो बेचा गया है. ये दूसरे के सेल डीड का एडमिशन है. नाउ मेरे सेल डीड में दूसरे का नाम नहीं है, इसके बेसिस पे ये इसको वेट कर रहे हैं. Well, I have also not seen the registered deed of sale. Otherwise, I could even concede or not concede. May I take break either in the second half or in the...
अब लेके आइए देखते हैं उसमें क्या boundary
हाँ ये better.
लेके पास
Item
Tomorrow.
7.
कल
हाँ कल
सेकंड आप बोलेंगे तो
सेकेंड अब एक केवल देख लेते हैं अगर डीड होगा तो अदरवाइज
नहीं भी होगा तो भी देखते
ठीक 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 ठीक.
Item 7, second appeal 177 of 2022.
आप ऐसे ऑर्डर के हिसाब से बाउंड्री बना के लिखिए. ऐसे ही स्केच में आ जाएगा.
जी यही प्लीज. This is judgment of reversal. This is very good case. This is plaintiff's second appeal, my lord, against the judgment of reversal. Suit filed by the plaintiff for declaration of his title and possession was decreed by the learned trial court, which has been reversed by the first. Now, my lord, this is a specific case of the plaintiff that the suit property was purchased by the plaintiff in the year 1976-7 from the recorded tenant. One of the recorded tenants, my lord, there were several recorded tenants. If my lord, can you take note of it that in Khata number 260, the recorded tenants were in Khata number 260, recorded tenants were Sugan Saw and Girdhari Saw. That is one share. And Devki Saw, Saman Saw, Baiju Saw and Tulsi Saw. Two share and Masumat Budni. They were the recorded tenants. Devki Saw, Baiju Saw, Saman Saw, Tulsi Saw. And Masumat Budni. They were the recorded tenants of Khata number 260, situated at village Meatu, PS Katkom Sahib. Now the plaintiffs purchased altogether 39 decimal 0.39 acres from Baiju Saw and one widow Masmat Futwa, one of the recorded tenants.
ये तो मौसमान दुगनी है.
नहीं वो बुधनी से नहीं लिए. बैजू साल जो है जिनका जो रिकॉर्डेड टेनेंट है
और
एक रिकॉर्डेड टेनेंट के लीगल ईयर मसुमात फुतवा थी उनसे लिए. Values of name is very much clear. That is why registered deed of sale dated 26/3/1977. Thereafter a mutation was done, rent receipt was issued. Now suit property is only 0.03 acres.
0.03.
03, but 3 decimal. Only 3 decimal is this suit land. Out of this 0.39.
Yes.
Defendant appeared, he contested the suit by filing written statement, and their main case was
Who purchased 0.39 acres?
no, I purchased my this 30,
Plaintiff.
39 decimal का ये part है, 3 decimals out of 39.
Okay.
Now the defendants in repleading, they have stated that this plot number 32328, ये जो सूट प्रॉपर्टी है 3 डेसिमल वाला, उसका प्लॉट नंबर 2328 है 2328. Now that is their specific admission case in the written statement that this 26 decimal was orally gifted, oral gift to one Purohit Yogendra Pandey.
26 decimal.
Yes,
Out of this 0.39.
yes. Now, thereafter, that is their case that summons or recorded tenant has no issue. I will show from the record whatever I am stating.
नहीं आप उनको issues बताइए, इतना कहानी नहीं.
नहीं माइलर बहुत इंपॉर्टेंट है, नहीं तो फिर केस ही नहीं समझ में आएगा, बहुत हौच पौच है. विकल्प एक लाइन केवल बचा है. डिफेंडेंट्स केस
देखिए
इज
आपको जो इस तरह से कोई आर्गुमेंट करना है ना, तो उसको जिनोलॉजी ढंग से लेके आप इस तरह से बोलते रहेंगे, हम कितना लिखते हैं. There is a limit to which I can just keep on writing their names and everything. ये sequence आपको लेके आना चाहिए ना. When there is so much of genealogy, you just do it tomorrow. You just bring it properly. ऐसे नहीं हो सकता. Essay number 177 of 2022, Counsel for the Appellant submits that he shall prepare a short note for the purposes of framing substantiation. इतना लंबा जिनोलॉजी और सीक्वेंस हाथ से लिखना पॉसिबल नहीं है.
उसमें एक्चुअली कर ली.
From daily list for orders to effect item 1, first appeal 88 of 2017.
Yes.
Three defects have been pointed out by the First is the court fee has been deposited. That has been deposited on 32. It's today. Have you got the statement? Today itself, the party has come for depositing the fee. Second is substitution petition.
Counsel for the Appellant is present. कोर्ट फीस आ गया ना, बिना कोर्ट फीस के
आ
आप
गया. इसमें आ गया.
that the surviving defects be removed within the period of 1 week.
Court fees may not be given to them because they are very poor people. They are arranging the money. Rest the defect is that regarding the
कोर्ट
substitution.
फीस आपका बोले ना, कोर्ट फीस आ गया है
इसमें आ गया.
आपको फीस.
इसमें आ चुका है. Substitution is there and limitation is there.
बिना कोर्ट फीस जमा किए आपका कौन सी चीज का ऑर्डर हो जाएगा? आ गया मतलब आप जमा कर दिए हैं?
जी सर, ये भी
Have to file. Have not been filed yet. कैसे बोलते हैं?
नहीं, ये आ गया टुडे इट्स
Today itself has been filed तो हमारे नोटशीट में नहीं आएगा ना?
तो दैट व्हाट आई एम
देखिए, within a period of 1 week payment. फाइल कर देंगे तो वहाँ जाके satisfy. फर्स्ट अपील का ये सब बिना कोर्ट फीस के लिए क्यों केस लेते हैं?
सेकंड ये फर्स्ट टाइम में कैलकुलेट नहीं होता है आफ्टर
कैलकुलेट तो खुद को तो करना होगा ना, आप वकील साहब हैं, आप कैलकुलेट करिए.
जब सेकंड इनका ये स्टाफ रिपोर्टिंग होता है दैट टाइम द कोर्ट फीस इज कैलकुलेटेड तो सब
आपको नहीं आता कोर्ट फीस
तो
कैलकुलेट?
उस बहुत सेकंड टाइम आता तभी कैलकुलेट करके मंगवाते हैं तो
इसीलिए प्रेम फ्री ऑर्डर होते रहता है, आप केस डिस्मिस होते हैं.
लैंड यूजर से रिपोर्ट
इसीलिए केस डिस्मिस मत कराइए ना उनका. 1 week प्रेम फ्री, ठीक है? If the defects are removed within time, post on 3rd of March.
अदर डिफेक्ट्स आर आल्सो
I do not know, आप अपना चेक करिए. इसका कोर्ट फीस नहीं फाइल हुआ है as per records के बारे में हम बोल.
Item 2, First April 89 of 2017.
in this case the court fee has not yet been filed.
Same order. These are all prem free orders.
Well, it's
1 week pending.
1 week pending.
the order में on the sufficient point
कैसे सब्स्टिट्यूशन? कुछ नहीं होगा जब तक कोर्ट फीस नहीं होगी.
Item 3, First April 90 of 2017.
same order filing pass.
Same order.
Item 4, First April 91 of 2017.
Same order already filed. Court fees.
आप चेक कर लीजिए, ऑफिस नोट से चेक करके चलिए. कोई भी डिफेक्ट रहेगा तो आपको दिक्कत होगी.
Item 5, First April 98 of 2017.
Same order. This court fees has not been deposited.
Item 6, First April 1114 of 2024.
Same order.
Same order.
Item 6.
6.
Item 6, FA 114 of 2024.
ये ऑर्डर सब अपलोड करने होंगे. देखिए FA number 114 of 2024. As per the office note, the certified copy of the judgment dignitary of the original suit was sent to the court concerned, but the same has not been received after the revision. Office is directed to send this list as express reminder. Close this case on 11th of March.
From date list for admission, item 11, First April 305 of 2023.
sole respondent.
Yes, Your Worship.
Will admit it formally? Will admit it formally?
Yes, Your Worship. On the last day, it was admitted and LCR also was called for, Your Worship.
Formally कुछ तो नहीं. कोई और आइए तो नहीं पेंडिंग. देखिए number 305 of 2023. Nobody appeals for document. Also for the respondent is yes. You have not filed for Kalappan.
Yeah, Your Worship.
She intends that he has already filed for Kalappan on behalf of the sole respondent. The records have already been received from the concerned court. That this appeal be admitted for filing hearing. When this appeal is admitted, what is the matter?
It's against money super, Your Worship.
They were the defendant or the plaintiff?
They were the
They were the defendant.
defendant, Your Worship.
There, counsel for the appellant is present. Admit कर लेते हैं formally.
LCR has been called.
LCR से बाद यार मस्जिद तो आज जाना.
It has to be formally admitted.
आपको करना है?
मतलब डेट में भी करना है.
वो हम देख रहे थे क्या मैटर है. इनका appearance record करो. Appearance में बोलिए. Admit, right? Post this case हम कब करेंगे?
Any day after 3 weeks. Any day after 3 weeks.
Post this case on 19th March.
Right.
For hearing under order 41 rule 11, item 12, second appeal 551 of 2017.
2017 का भी अभी पेंडिंग है. कितना साल हो गए? मतलब क्या हो क्या रहा है इस केस में?
So certainly some amendment. IE was filed for amending the date of the second appeal lordship. Thereafter, it has been amended. There were certain anomalies in the readings which has been corrected lordship. Time cross on the idea is
बताइए क्या?
lordship may see.
You are the plaintiff or the defendant?
I was the plaintiff. Suit was dismissed. Against that, the first appellate court, the civil appeal number 03 of 2016 was filed. That was also dismissed, lordship.
So concurrent finding.
Concurrent finding. The plaintiff, in fact, he has claimed right title and interest over a piece of land that is a government land by means of an adverse possession. Lordship may see page 24, that is the appellate court, the first appellate court.
First the
judge.
trial court.
Yes.
First we will see the trial court.
Lordship may see para 3. My case is plot khata number 202, page 25, plot number 524, area measuring 2.00 acres, corresponding to RS plot number
नहीं पहले ट्रायल कोर्ट जाए.
trial court judgment. Trial court judgment it begins from page 15 lordship. Page 15. The present suit has been brought under the for decree of declaration that plaintiff is the owner of the suit land having his right and title based on adverse position over the same and for decree of convention peaceful possession. Para 2. Land under Khata number 202, plot number 524, RS plot number 240, situated at Nauza Devghar within PS MGM in the district of described in schedule of plate is the subject matter of the further the suit land was previously khas land is full of jharis and bushes. The ancestors of the plaintiff, being Kukati settled reyes of village Mango, reclaimed the suit land by cleaning the jhari bushes and made the same land cultivable within the knowledge of ex-landlord of the village in the year 1946. They are claiming that their ancestors were in possession of the land since 1946 after the oral settlement made by the from him prior to 1946, and since after reclaiming the land, the ancestors of the plaintiff came into possession in the suit land prior to 1950 by way of making cultivation. Thereafter, Lordship, I am speaking certain lines. The plaintiff has been cultivating pulses like Bhutti, Rahar, Gora, paddy in the suit land right from May 1960. Ancestors were in possession of the land since prior to 1946, and the plaintiff he came in possession of the land since May 1960 continuously and uninterruptedly, fully converting the land into cultivable within the knowledge of all concerned. Thereafter, Lordship, they remained in hostile position in spite of continuous proposal granting the suit land. It is further pleaded the proceeding under section 3 of the BPLE Act clause initiated against the plaintiff, being BPLE case number 11/11 of 1991 in the Court of Circle of Jamshedpur, and in the aforesaid proceeding notice was served upon the plaintiff accordingly filed so called stating inter alia about the reclaiming of the suit land and also about the continuous possession therein. The circle officer made inquiry to the circle inspector Jamshedpur who found the act of the possession of the plaintiff, and by the order dated 19/9/91, the circle officer finally dropped the said proceeding. This circle inspector he has deposed in favor of the plaintiff lordship. Finally dropped the said proceeding keeping in view the under continuous cultivating position of the plaintiff in the suit land, and in the last survey settlement, although the suit land is recorded in the name of the state of Bihar, yet the plaintiff remained in continuous possession. The state never possessed or claimed the suit land. Further, it is pleaded the wrong entry in the survey record based on erroneous reporting of the Karmachari does not distinguish the occupancy right of the plaintiff in the suit land, which he acquired after continuous and undisputed possession over the same. Thereafter, Lordship, the cause of action which has arose on 15/11/2006, Circle Office Jamshedpur came into the suit land and attempted to interfere in the process of cutting crops of the plaintiff in the suit land, but due to wrong assistance, they went away from the suit. Thereafter, Lordship, it is further notice under section 80 of the CPC was served to the Deputy Commissioner in so and so. Next page, Lordship, page 17. On 21/12/2006, under registered post with it is further pleaded that Deputy Commissioner is Simbu Jamshedpur by letter number 847 dated replied to the notice under section 83 giving through his lawyer admitting the cultivating position of the plaintiff for the last 40-45 years after reclaiming the same by cleaning the bushes, and he also admitted of proceeding BPL case number Roman 2/11 of 1991. Further, it is pleaded that he has adjoining Rajiti land at Pokhari village adjacent to the suit land of Moja Devghar, and since after reclaiming the same, he has been in continuous cultivating possession over the same to the knowledge of all concerned for more than 40-45 years. As such, he has valid title right in the suit land based on his undisputed continuous adverse possession over the same. The cause of action for filing this suit against the defendant arose on 15/11/2006, 11/12/2006, and 24/2007 on subject Moja Devghar, district is removed within the jurisdiction and for the purpose court fee and jurisdiction of the value rupees 1 lakh declaration of the source. Now, schedule of the land has been given lordship, and thereafter 7 issues were framed, page 18.
First issue is lordship, is the suit as framed maintainable and has a plenty valid cause of action, suit barred by limitation, skillful waiver and accuracy. Is the suit barred under the provision of BLRA? Fourth, has the plaintiff acquired his right title over the suit land as described in schedule of the plaintiff paragraph adverse possession? This issue number 4 is important. 5, is the plaintiff entitled to a degree of confirmation of possession of the suit land as claimed? Then permanent injunction against the state. Now, lordship, there are 5 plaintiff witnesses have been examined. One is Amal Kumar Kaur, second is Bharat Kaur, that is he is the plaintiff. Third is Birbal Gaur, fourth is Bharat Dubey, and 5 is Dayanidhi Singh. They 4 and 5 are government servants. They have deposed. All the 5 witnesses have been cross-examined before the court. On behalf of plaintiff, following documents. Exhibit 1 is the carbon copy of notice under section 80 CPC. Exhibit 2 is the postal receipt. And Exhibit 3 is the certified copy of the order dated 1999 past DPP case number so. And Exhibit 4 is the certified copy of the Katiyan. Thereafter, certain judgments have also been cited. Now, lordship, the trial court, they took up issue number 4, 5, and 6 together. These issues are on page 19. I think the plaintiff pleaded in his plaint suit land was previously khas land with full of bushes, and the ancestors of the plaintiff being petty sector presence of village. Mangu reclaimed the suit land by cleaning the bushes and made the same land and within the knowledge of this land. In the year 1960, plaintiff has been examined as PW2 in cross-examination that he did not know the name of the lender. However, he explained in para 19 of the approved title of property of his ancestors of the suit land, but no such evidence is included. It is also explained in para Jindal God has not settled the suit land in his favor. It was pleaded by the plaintiff that after demise of the ancestor of the plaintiff came in possession of the suit land in the year 1960. Prior to 1946, the ancestor, thereafter since 1960, the plaintiff are in possession. Since then, he has been doing cultivation of the forested land within the knowledge of all concerned, knowledge of officers of revenue and state. During cross-examination, he explained in para 22 that revenue was never paid by him, and in this regard, no order has been passed. However, he explained that he submitted petition to pay revenue, but he failed to explain the order of his petition. Even he explained that he had no knowledge of filing of year of such petition by him in the court. In plain suit land has been described in the schedule of the same area 2 acre recorded khata number 202, plot number 504, corresponding to RS plot number 240, Mauza Devgar, survey farm number so and so. It is clear that as per the plain, suit land is situated at plot number 504, of khata number 0. We exhibit 3 of the certified copy of the order dated 1999 past the BPL. The Khatyan have been filed. From perusal of Exhibit 3, it is clear said order is recorded with piece of land situated at plot number 524, khata number 202 at Mauza Devgar. Obviously, it is different from suit land in plain. Exhibit 4 is Khatyan of khata number 2 is Khatyan in the column of Asami, Anabad, Bihar Sarkar. The plot number 504 is nowhere mentioned. Rather, this part is very important also. Now, in the Khatyan, in the column of Asami, plot number 504 is nowhere mentioned. They are saying, rather plot number so and so have been mentioned. So, they are disputing the BPL case. In BPL case, plot number 524 is involved, plot number, and suit land is 504. Then 3W3 is another important witness. Mentioned parallel, the suit land was reclaimed for agriculture purpose by Bharat Gaur plaintiff. The statement is contrary to plaintiff in para 2. The suit land was reclaimed by his ancestor. There is no contradiction lawsuit. It is the plaintiff case that prior to 1946, his ancestors reclaimed the suit land.
No, PW3 says that it was reclaimed by the plaintiff.
They thereafter said the statement on as he pleaded in para 2 of the plaintiff, suit land was reclaimed by his ancestors. Again in para 12, this is before 50 years of father, 50 years, father of Bharat Gaur reclaimed his land. Bharat Gaur is the plaintiff before. 50 years father reclaimed this land, but plaintiff never explained such fact that he is claimed by his father. That is the fact, lordship. The plaintiff has already explained prior to 1946, his ancestor and his father has reclaimed the land, and after 60, he is in possession of the land. In para 11, 16 of this is the revealed this ability to explain plot number of piece of land situated nearby the Suklan. He has no knowledge before he claimed the Suklan. PW4 explained in para 4, 10 of his cross example that the suit land is khata number 02, plot number 524. Obviously, this statement contradicts statement pleaded in the suit land situated at plot number 504. In fact, this witness is a retired employee of Revenue Department, posted as Circle Inspector in the year 1977-17. Para 13, this witness to settle revenue report was submitted by him to Circle Officer, but he has no knowledge whether it was settled in favor of the plaintiff or not. Even he has no knowledge that whether this report was considered right report or not. PW5 is Halka Karamchari, posted in the office of Circle Officer. This witness explained in para 19 and 13 of his law on the basis of notice under section 80 CPC, he received order of inquiry and he completed it, but no such inquiry report has been submitted from the side of the plaintiff. It is also explained by the witness that under the direction of Circle Officer, he inquired, but he has no letter in this regard. Such letter is not published. From the on the basis of PW, claim of adverse possession is not well established in the favor of the plaintiff. Lordship, in fact, the report of PW4 and PW5, it clearly indicates that there was an adverse possession by the petitioner. Plaintiff was in possession of the land, so report was sought for ultimate.
No, even the record of right did not indicate that you were in possession of the property. You
Record
never
of
challenged
right.
the entry in the record of right.
Record.
Record of right indicated that the government is in possession of the property. That is why the appellate court has said that no specific date, nothing could have been proved by you. You could not, you said that in your cross-examination that you can prove your property right, but no evidence was led to that effect. You have not, you say oral settlement, correct?
That was
No
also-
rent receipt of zamindar, no rent receipt of zamindar, so there is nothing called, no possession was proved by you. What is the proof of your possession?
Proof of the possession, Lordship, in
For,
fact,
since 1946?
1946, Lordship.
Show me one document that you were in possession of the property since 1946.
In fact, Lordship, as per the revenue records, there is no revenue record to show that I was in possession of the
Yes,
land.
there is nothing with you also.
But so far the
When the
revenue,
landlord has settled the property with you orally, then it has to be coupled with rent receipt by the landlord in 1946. There is no evidence
Why?
that you were in possession of the property since 1946. Rather, there is evidence that your presence was not there because in the survey report your presence is not recorded.
Lordship, reply to that evidence, revenue record neither creates
No,
any
they
right,
will not create. But how do you?
neither distinguishes
They
any
will
right.
at least show your possession. There is no evidence of your possession.
BPLE Act, in fact, and the inquiry
That is not-
inquiries
that
made
is
by the
not-
PW4 and 5 that clearly indicates that I was in possession of the land and
No.
accordingly order was
There are
passed.
nobody.
Lordship, one judgment may be seen, Lordship.
Yes, please give me the date.
ये 2019 8 volume 8 Supreme Court cases page 7 to 9
2019,
volume 8 Supreme Court cases
volume 8,
yes Lordship page 7 to 9
7 to 9.
para 22 and 50 it clearly says Lordship Lordship may say that there are certain indications in the impugned order itself that I was in possession of the land but there is no documentary proof to
No proof. There is no
to prove that I was in possession of the
no
land.
proof at all.
In order to prove my possession, Lordship, is it adequate? The possession is adequate and
Honorable
it
Learned
continues.
Counsel appealing on behalf of the appellant. This appeal has been filed by the plaintiff against judgment of information. The Learned Counsel, judgment did it? The Learned Counsel for the appellant has submitted that though there is that the plaintiff had filed a suit seeking declaration of adverse possession with respect to the property involved in this case against the government. He has submitted that as per the case of the plaintiff, there was oral settlement by the landlord.
One thing I
By
will add,
the-
Lordship, prior to that in Dwara Sahib case 2014 lordship, it was said कि adverse possession you can use this as a shield, not as a
हम
sword.
कहाँ मना करते हैं?
But by this judgment, it has been Honorable Supreme Court has said even adverse possession it can be used as a
कहाँ
sword.
प्रॉब्लम है इसमें? आपका तो एपेलेट कोर्ट बोल रहा है आपका प्रूफ ही नहीं है अबाउट पोजीशन. We are not on that. That law is settled that you can claim adverse possession against government also, and and you can file a suit also for that. वो तो settle हो गया उसमें कोई दिक्कत नहीं. The learned counsel for the appellant has submitted that the suit land was orally settled by the ex-landlord in favor of his father, who reclaimed the property and started cultivation. And thereafter, since 1946, they have been in continuous possession of the suit land. And the plaintiff slash their ancestors had perfected their title by way of adverse possession. The learned counsel has further submitted that the learned appellate court, while considering the matter, has failed to consider that PW 4 and 5, who were government officials,
Yes, ma'am.
had supported the case of the plaintiff, and therefore their evidence was not properly considered. The learned counsel has also submitted that it is well settled by now that adverse possession can be claimed by filing a suit and need not be just a matter of defense by the defendants. After hearing the learned counsel for the appellant and after going to the improved judgment passed by the learned appellate court, this court finds that the learned appellate court after going to the judgment passed by the learned trial court, this court finds that the learned trial court considered the materials on record and found that the basic ingredients of adverse possession were not satisfied by the plaintiff. However, the learned trial court also observed that the plea of adverse possession cannot be used as a sword, but can always be used as a shield. The learned, however, the learned trial court, by considering the materials on the point of the satisfaction of basic ingredients of adverse possession, has scrutinized the evidence of the plaintiff and also that of, particularly that of PW 4 and 5 and recorded that the discussion of the evidences could not establish the claim of adverse possession of the plaintiff. The plaintiff, during his cross-examination, had explained that could not even disclose the name of the landlord. And in further cross-examination, he stated that he could prove his right of Kutkatti of his ancestors, but no such evidence was produced. The Khatyan revealed, the exhibit 4, which was the Khatyan, revealed that the property was shown to be recorded in the name of the government. And this happened in the survey operation with respect to the land. The learned appellate court also considered the materials on record and has also considered the evidence of all the witnesses, including PW 4 and 5. And a cross-examination of the witnesses have also been taken into consideration. The learned appellate court also recorded that the exhibit 4, Khatyan of Khata number 202, showed that the plot number 524 of this Khatyan is Purani Parti land recorded in the name of Anabad Dira Sarkar, along with plot number 183 and 673. The learned appellate court recorded the finding in paragraph 19. The learned appellate court ultimately recorded the finding in page 34 का pattern. Page 34 से finding ले लेंगे. This court finds that both the courts have scrutinized the materials on record and have recorded that the applicant failed to prove his plea for adverse possession. The fact remains that admittedly no documentary evidence, any rent receipt or any settlement document was filed to show the possession of the appellant since 1946. The oral evidences have been duly considered, and after scrutiny, the order has been passed. This court finds that there are concurrent findings recorded by both the courts after scrutinizing the material and recording. No substantial question of law arises for consideration in this case, which is here discussed. Yes. There is one matter we heard in batch. काफी थोड़ा टाइम भी हो गया है, थोड़ा सा मेमोरी से थोड़ा इरेज हो गया. सो आई जस्ट वांटेड टू पोस्ट इट ऑन वन डे. थोड़ा सा सुनना चाहते हो कौन सा डेट आप लोग को सूट करेगा, देन आई विल पास इट. क्योंकि जब 3 महीना बीत जाता है तो ऐसा प्रॉपर भी नहीं है इस तरह से जाता
Next week, any date as per matters convenience.
है. तो थोड़ा सा खाली ब्रश कर देंगे तो उतना में हो जाएगा. मतलब कुछ लग रहा है कि कुछ गैप है, मतलब आई एम नॉट एबल टू एक्चुअली पास दैट जजमेंट. आई जस्ट पोस्ट इट, इट इज एन असाइन्ड मैटर.
Yes.
आई पोस्ट इट एंड देन थोड़ा सा आप लोग 10-10 मिनट भी थोड़ा ब्रश करेंगे तो हो जाएगा. ठीक है, एक दिन हम उसको प्लेस करेंगे तो उसी दिन कर लेंगे,
हाँ.
या तो उसी दिन कर लेंगे या उसी दिन कर लेंगे.
Well, it depends, but it's subject to minors convenience.
ठीक है, हम उसको पोस्ट करेंगे.